there's three ways of attacking these cases, the way that I think. A, the admissibility of the documents, and also A, the arrest. We don't need to talk much about a warrantless arrest. You all know how to attack probable cause. Fortunately, that's one field where Evidence Code Section 664, the official duty presumption, does not apply. The lawfulness of an arrest is not presumed. So the admissibility part we're going to talk about more today, and that deals with foundation, competency, authentication, hearsay, 13380, the vehicle code, the McDonald versus Gutierrez type of issues. The second area that I'm going to talk about is the breach of duty. Under the law, if you can show through affirmative evidence or cross-examination of the cop that any official standard, statutory or regulatory, has not been observed in any respect. Okay? You have now rebutted the presumption of reliability and shifted the burden to the DMV to establish the reliability, which means that they're going to have to bring in a toxicologist, much like they did in some of these phlebotomist cases, and try to lay an Adams foundation that the person who administered the test is competent and qualified, that was properly administered, and that the machines are properly working order. Okay? They're not going to do that. Although we did see that happen a little bit when we were attacking the phlebotomist, the unlicensed persons under 23158. Okay? And so every time we do something, DMV reacts. But that's the first time I've seen that. Occasionally, you hear from other places in the state that they will bring in the toxicologist to establish that foundation for the reliability. But once you show any standard in any respect has been violated, the burden shifts to them. Because as it starts out, you have the burden, assuming that they have admissible documents. You have the burden to come forward and show that there's a problem with the foundation, that there's an official duty that has been breached. Now, that can be, the official duty can be anything. It can be Title 17, 1219.3, the failure to continuously observe for 15 minutes. It can be the failure to properly admonish a person. The Nelson versus City of Irvine situation, where the person insists on a breath test and unfortunately they're given a blood test. They have a duty under the statute to give you that type of test that you demand. Any statutory duty, any regulatory duty. With the regulations too, you see some materials in there from the Department of Health Services where they have approved certain breath test methods and blood test methods for San Diego, for the San Diego Police Department, for the county. And if you can show failure to observe any of those. I've included some very interesting information there in blood test cases. Basically, we know that our expert could come in and say that you have to, for example, mix the preservative with the anticoagulant and the sodium fluoride preservative. However, we now have documentation, and it conflicts, by the way, in the materials that I provided. It says that, well, at first they said that you have to vigorously shake it, and now they're saying that you have to gently filter it. But it's got to be done, and now we have it documented. Okay, we can't have a DMV hearing officer now saying that I don't find the expert credible. We now have approved methods that we can give the DMV, and that's in the materials. They have to accept those documents. There's plenty of ways to get the DMV documents. If you want to get the DMV some documents, whether it's a declaration of your client under CCP, or whether it's a declaration of your expert, or whether it's a hearsay document, which you can offer, or a document which you want them to take official notice under the government code, or a document that's a scientific or technical matter that they could take official notice of, and there's some examples and documents and materials on how to do that. Just serve it on them. Serve it on them 10 days in advance. Okay? A declaration from your client rather than have your client testifying. If they don't object within 7 days, that document comes into evidence and your client doesn't have to testify, and the statute says it's as if it's live testimony. Live testimony, and they don't get a chance to cross-examine.